Hi, everyone, and welcome to this module called The Future of Law and Generative AI. I am Daniel Gold and very excited to talk with all of you about this great and exciting topic. I'm going to do my best to keep it exciting, informative, and hopefully somewhat entertaining throughout this hour. But before I get started, I want to give you a little bit of information about me and also why I'm qualified to speak with all of you today on this important topic. So I graduated from law school back in 2002 from Syracuse University College of Law. Please don't hold that against me. I grew up in the Northeast, so went to school up there in the Northeast. And after I graduated from law school, I like to say what I had next was really phase one of my professional career and the legal software services, as well as my legal profession all in. So I started off by clerking for a judge in the Superior Court of New Jersey, and that is something I like to call the fourth year of law school. Clerking is highly informative, very, very helpful, highly educational. I hope all of you have the opportunity to be able to do that after you graduate law school. Now, after I finished that clerkship, I went on to go practice, and I'm going to spend some time talking about what that was like during my practice. But at the tail end of that tenure, one of the things that was very interesting was I started seeing a very interesting and distinctive trend, which was the whole entire legal profession was moving away from paper and they were going over into something that was digital. So discovery, interrogatories, etc., they were all becoming digital. And that trend was leading to not reviewing all of the discovery in paper, but a little bit more online, a little bit more digital. We're definitely going to talk about that. But it was at that point in time that we had a LexisNexis sales rep who was telling me about what LexisNexis was doing in this world of digital or electronic discovery. And Lexis had acquired several different software programs, and those software programs were all about the collection, the processing, the digitizing of all of this data and giving it to lawyers to review in a software platform. That sounded actually very enticing to me because I had a love of technology and I also had a love of law. And at that point in time, it looked like a very good way to be able to fuse both of those. So fast forward, my family and I moved down to Charlotte, North Carolina, and there I was going from the practice of law more to the business side of law, and really not just selling, but really educating lawyers all over the Southeast. And that's what I really call phase two of my legal profession, working for LexisNexis for over 7 years. Now, in that over 7 years time frame, very interesting things happened in the world of legal technology. Data volumes and data types were exploding. The types of ways in which we were looking at data continuously changed. And when I saw the writing on the wall about how the whole entire legal technology field and the way the profession was moving, I moved with it. And again, similar to LexisNexis, I was in the right time, the right place. Moved family from Charlotte, North Carolina, here to Kansas. And then that's what I like to call phase three of my legal profession. Now, phase three, that's when we moved over into Kansas, worked for a company based out of Olathe, Kansas, called Iris Data Services. It was a very exciting time because we changed the entire legal profession, but as it relates to how service providers were offering up legal technology. Now, the details of that are not very important for purposes of this presentation, but this thing called e-discovery managed services, this little company out of Olathe, Kansas, completely changed the paradigm. No one had even heard of that concept until Iris. We did so well that we got acquired, and then we did so well we got acquired another time. And after being acquired a couple of times, I decided to try my hand in the world of information technology, or IT. And so I went on to become a VP of IT managed services company. And I found myself really entrenched in the world of Microsoft and how the world of Microsoft impacts law firms and also corporate legal departments, because those are who some of our clients were. And that was really interesting to me, and I spent a lot of time really understanding the deep world of Microsoft, and then eventually got pulled back into e-discovery. Went over as a principal solutions consultant for a software company known as OpenText, and then I got a phone call one day. And that phone call one day in 2019 was, hey, this is BDO USA. And BDO, in case you don't know, is a top advisory and consulting firm. They do a lot of accounting, tax, audit, assurance work, but they also do a lot of forensics work, and in particular, forensic technology. And the phone call I got was my future boss, and he said, we heard you know a thing or two about this thing called e-discovery and managed services, and we'd like you to come to BDO to start that group. And so that's what I like to call phase four of my legal profession. And if you notice the gray in my beard, I'm hoping this for sure is my last phase of my legal profession, in which I retire here at BDO. I am a principal, or otherwise known as a partner. I'm a partner at BDO within the forensics practice. I lead their e-discovery managed services practice group. And as part of that, I also did a couple cool things, which is I am getting a patent on a product that I invented called Athenergy. Athenergy are business intelligence platforms that sit on top of the e-discovery software. And I also happen to be a podcaster, which I also will cover later on in the presentation. So that's a little bit about me, why I'm qualified. The objective for our time here together is that we're going to explore the impact of generative AI on the future of law. We're going to gain a historical perspective, something I hopefully will be both educational and entertaining, something I also like to call edutaining, in the legal field, and examine the growing opportunities that artificial intelligence offers in areas like legal research, drafting, e-discovery, and much more. Now, in order to be able to do that, we're going to look at this presentation in four different phases. The first phase is we're going to talk about the evolution of legal technology. That's going to be pretty cool. Second, we're going to talk about the growth of data volumes as well as data types. Third, we're going to talk about the history of artificial intelligence and its use in the legal profession. You might be thinking that may be boring. Hopefully, I'm going to prove you wrong. And then finally, while you did cover ethics in another module, I'm going to talk about some of those ethical considerations in generative AI and legal, but also ways in which all of you that are listening to this can keep abreast of all of the changes that are happening in this field, which are going to be so important. Now, I started this off talking a little bit about me, my background, and why that was relevant for purposes of this presentation, this module. And one of the things I said is that when I got to this law firm, I had this LexisNexis rep. It was talking about technology, but technology was not the focus of this law firm. Now, keep in mind the year was about 2003. It's not that long ago, although it feels much longer than it is. But I walked into the practice of law. Here's what I saw. I got into the law firm. They escorted me to my office, and they showed me in my office. And there on the desk was not a fancy computer, but rather there were Redwells, there were banker boxes, there were legal pads, there were highlighters, there were sticky notes, and then there was this thing. Yes, this thing. Now, when I'm live and I'm doing this presentation, I often ask for a show of hands. Does anyone know what this machine is? Because this is a machine, all right, and it's a little bit bigger than what it shows there on the slide. Now, that is what we like to call a dictaphone. Now, a dictaphone is what you dictate into, so it records. You put an audio cassette tape into there, and you record your voice. Now, why in the world would I have that? Well, that's a good question. So in our law firm, all of the partners and all the lawyers would dictate all of their motions, all of their briefs, all their memoranda, all of their letters to clients into this little machine, and then give the tape over to our legal assistant who would then transcribe it, then would print it out and give it to us for review and make edits, etc., etc. Now, only ones, if you didn't catch that, who had computers at this law firm were the legal assistants, not the lawyers. We all had to dictate. So needless to say, by the time I left that law firm, I had gotten my friend who was a consultant for law firms, did technology work. He networked everything. He even put data backups, and I even went home with this little data backup tape, because that's how data was backed up, was literally on a physical tape. And they trusted me to go home with it, a first-year associate. So be it. In any event, needless to say, even though this was 2003, I bring up this point very, very methodically here because the world of legal technology and us as lawyers hasn't really evolved much. And in this nice image that I like to take credit for because I made it on the screen, what that's showing you is that my way of being able to tell you that the legal profession has not evolved that much. Our adoption, I should say, of legal technology hasn't evolved that much. And so just like humans have evolved slowly, so too have lawyers in adapting to new technologies. Now, ironically, the one technology that we adapted to so fast was, sure enough, as you can see, the Homo sapien, the modern human over there at the very end, standing nice and tall, is holding an iPhone and an iPad. And sure enough, that was the innovation, the invention that got lawyers starting to think a lot about technology. Interestingly enough, back in 2007. Now, it's not just me who's evangelizing that lawyers have been very slow to adopt, right? It's also people like Dev Stalkoff, who's the vice president and deputy general counsel over at Microsoft. She said that the legal market and lawyers are incredibly slow at change and digital transformation. But legal cannot afford to do that. They cannot afford not to transform. The world around us has gone digital. We cannot lag. We must scale to meet new demands, and we will need to leverage tech to do this. And she is 100% right. But yet, while she's 100% right, what I'm going to illustrate to you is really just almost the opposite, right? The evolution of legal technology has been very slow in the legal profession. If you take a look at what we like to call the innovation curve, right? The innovation curve, lawyers are not the beta testers. Lawyers are the laggards. We're always the ones who, because we're looking at risk so much for our clients, we look at risk for ourselves. And so it's risky to use a lot of modern technology, right? So let's think about some of the things that we've been using over time. So one of the things that we use when we produce data to the other side after we've propounded all of our discovery, right? When we're producing it, we have bait stamps. Well, that phrase bait stamps actually comes from a person's last name. Edwin G. Bates invented the Bates stamper all the way back in 1891, the World Fair. Filed a patent on it, the whole bit. And this bait stamp was an actual physical stamper, and it was big, like you can see. And my legal assistant actually had, and so too did all the other legal assistants when I practiced, had these physical bait stampers, and you would really like hammer this thing, and it's so loud, give you a headache. When you punched it down, it would automatically change the number. So numerically, it went from 1 to 2 to 3 to 4 to 5, et cetera, et cetera, et cetera. And you would bait stamp all the documents, and you'd use that in evidence. Well, thankfully, electronic software came around, and now when we refer to bait stamping, right, it's something that's all done digitally. We're not actually using the stamp anymore, but we're still talking about and utilizing technology that was invented in 1891. Now, you've run Google searches, I'm sure, and Lexis searches and Westlaw searches. You're utilizing something called Boolean searching. Well, did you know that Boolean searching actually came from a man named George Boole, who invented that searching algorithm in the 1800s? Now, I know what you're thinking. There was no computers back in the 1800s, no software, no databases, etc. But what he actually did was he created the logical underpinnings to allow us to be able to structure and filter information as we do in modern database and internet searches. So to give you an idea as to what George Boole actually created that ultimately led to utilizing a searching algorithm was he used the logic to formalize statements and syllogisms. So for instance, he would say, number one, all men are mortal. Socrates is a man, therefore Socrates is immortal. And that's a classic example of what George Boole or Boolean searching was way before computers. But again, here we are in 2024 and still utilizing the same searching ideas. Now, of course, there is the infamous, and we can never tear ourselves away from it, the infamous keyword searching. Now, keyword searching is interesting because that was invented in the 1960s and 1970s by this gentleman over here, Professor Gerald Salton at Cornell University in Ithaca, New York. Now, I'm a bit fond of Ithaca, New York, because I went to college at Ithaca College. Cornell was on the other side of the hill. But this is something that was used, that was invented and been started to be used in the 60s and 70s. Now, if you fast forward 10 years and you were fortunate enough and you had enough money at your law firm, you would have this ginormous red box of a computer. Yes, this is a computer that was sitting on your desk. And LexisNexis, all the way back then, had something called the Mead computer. And the Mead computer allowed an attorney to perform case law research as well as statute research and would utilize nothing more than keyword searching. And unfortunately, for better or for worse, sometimes I think it's worse, we have been stuck with keyword searching ever since the first lawyer had this red box sitting on her desk. So, but we haven't come much further, really, if you think about it, because the way we were doing discovery, even before I was practicing, was that we would look for the needle in the haystack, all the important documents and documents themselves, actual physical pieces of paper. And we literally review inside of warehouses, banker boxes, like you're looking at there on the screen, of boxes upon boxes upon boxes of documents. And literally everyone have to read every single page, code for relevancy by physically highlighting, putting flags, sticky notes, etc., and also doing physical reactions with Sharpies. Now, interestingly enough, even when I was working at LexisNexis, I heard of lawyers that were still, unfortunately, doing that right there. But we learned how to actually scan all of those documents. And when we scanned all those documents, we made them text searchable. When we made them text searchable, we put it into the software. And then we replaced those warehouses of banker boxes with warehouses with contract lawyers sitting in front of those very computer screens over there. And we had law school graduates and other young lawyers and older lawyers that didn't want to work at a law firm or didn't get a chance to get a job at a law firm, whatever the case might be, or they just loved doing document review. And they would be sitting over there in those little stations there doing coding and going from document to document, document, using, of course, at that time, keyword searching. And they're utilizing what I talked about before, which is a program called Concordance. That's the program LexisNexis bought in the 2000s. And this is really what the software looked like. And if you're looking at it thinking to yourself, oh my gosh, that's very antiquated looking, that is what it is. And we would, do keyword and do Boolean searching, and then we would code for responsiveness or relevance or attorney-client privilege in a computer screen that looked just like that. So that's a little bit of the evolution or lack of evolution, I should say, in legal technology. But I want to talk to you also about the growth of data volumes and data types. It has significantly impacted how we are navigating and going through documents. So the way I'm going to be able to do that is talking about the history here a little bit again. So again, when I'm live in person, I usually ask for a show of hands to say how many people actually recognize what that arrow is pointing to. In case you don't know, that is a floppy disk sitting in front of what was the Apple IIe computer. I actually owned that computer in 1989, and the only way for the Apple IIe to do anything at all is to stick a floppy disk in it, and you'd have to program something. Nothing ran by itself, and we didn't have nice interfaces. What you see over there on that computer monitor is literally what it all looked like, and sometimes it was worse than that. So it was all text-based, and all the graphics were a combination of letters and numbers to make graphics. In any event, that floppy disk held a whopping 256 kilobytes of data. Now, I'll tell you that a lot of your memes and a lot of your GIFs that you're sending to your friends, they actually have more data storage than what you were able to store on that floppy disk. And what's so fascinating now is, you look back, that's what we store data on. But now you can go to any major box store, retail store, off of Amazon, what have you, and you can get a terabyte USB flash drive that you can put on your keychain, stick in your purse, stick in your pocket, right? And you could literally hold a terabyte of data just like that. So it's fascinating how much data has grown, and the ability to have something that was a 5.25-inch piece of plastic down to a little tiny flash drive in which we're storing all this data. But one of the things I find is talking to both law students as well as talking to seasoned lawyers, we talk a lot about megabytes and gigabytes and terabytes, etc. Well, it's hard to understand what that really means in the world of like physical data. And so I thought maybe I'd take a moment of brevity here and also just a little comic relief here to talk about how much data in the digital world translates into the physical world. And a way I'm going to do that is by showing you a picture of this, which is the Library of Congress. The Library of Congress, obviously being the largest library in the United States of America. And if you were to digitize every single book in the Library of Congress, cover to cover, you'd come up with about 10 terabytes worth of data. Now, this is really significant for a couple of reasons. Now, I actually have cases for my clients that I'm working on that are up to 10 terabytes worth of data. So think about that for a second. If you don't have the right culling mechanisms, the right algorithms, the right technology, the right software, etc., and the right people behind it to know how to utilize the software, it's the equivalent of actually reading every single book in the United States Library of Congress from cover to cover, page to page. That doesn't seem like a very efficient amount of time. And if you look at that picture, my God, that's incredibly daunting as well. So that's 10 terabytes of data. Now, if you were to take paper and you were to stack it at the very bottom of the street in Chicago and stack it all the way to the very top of the Willis Tower, you would have a petabyte worth of data, right? So taking paper from the base of the Willis Tower all the way to the top, that's a petabyte. Okay. Now, I don't have any cases in the petabytes of data, and I assume that that may come very, very soon, actually. Give you an idea of the growth of volume, right? Next, after a petabyte, is a zettabyte. Now, if you were to take paper at one end of the Great Wall of China all the way to the other end of the Great Wall of China, you would have a zettabyte of data. Now, put that into context for a second. It is, there's a study that just came out by the International Data Corporation, the IDC, that said the expected global volume of data generated at the end of next year will be 175 zettabytes. That's 175 Great Walls of China. That's a billion terabytes of data. That's 100 million US Library of Congresses. Now, I just made that last word up. But that gives you an idea. Now, it's almost cliche to talk about this growing amount of data, but it's so important in the context of where we are today and why AI is so absolutely important. If you take a look at this slide, which you can see over here, is the sheer volume of data that is around us today necessitates us, it forces us really, shakes us, if you will, to rethink how we search. And if you take a look at this, when I started, back in 2003, practicing law, all right, and then I started going to LexisNexis. I was there around 2007, 8, 9, 10, 11, 12, et cetera. You can see the growth of volume steadily increases over time to where we are in 2025 next year. So that's a zettabyte. So we went from a terabyte, then we went to a petabyte to a zettabyte. Does anyone know what comes after a zettabyte? Because there is something after a zettabyte. All right. After a zettabyte comes something I like to call a yottabyte. Yeah, a yottabyte. And there is one of many bad data jokes I'm going to have for you. So you'll have to forgive me, but there it is. There's my first joke, yottabyte. All right. So the thing here is that all this data that I'm talking about over here, it's all going to be relevant for cases that you are going to have to handle. So all the data needs to be collected, it needs to be analyzed, it needs to be culled down. Now, historically, that's been really easy to do, or it's gotten easier to do. How? Why? Well, all of this data is what we call unstructured data. So all of your Microsoft data, your Excels, your Word, your emails that you've got, your PowerPoints, right? All of that stuff, right? That's all what we call unstructured data. What that means is that we could take that and put it into this proverbial electronic funnel, right? So we put all this data in, and the processing software, right, processes all the data, crunches it all down, and we utilize early case assessment analytics, which are in fact AI algorithms. And we utilize that to cull down the data to only focus in on what's important. Now, just as we got that under control, this whole thing of structured data came out. So structured data has been databases, like maybe a sales database is something that's really important. But more importantly, other structured data types that are out there, like text messages, are structured data types. And then we also have things called ephemeral messaging. So all of your Snapchat messages, your TikTok messages, your WhatsApp messages, even other messages called Wicker and Signal, etc. Any message that you could send and it disappears is ephemeral messaging. And it's highly critical for us to understand an investigation, any sort of litigation case. Now, obviously, because it's ephemeral, right? It's gone. We can no longer search for it. There are ways of being able to find the metadata, forensically collect that metadata. But all of this stuff is very, very important, becoming much more complex than it ever has, and how to be able to collect data. Even collecting data from an iPhone, because of the way Apple constructs their backend, has become increasingly difficult to forensically collect it and an easy way to be able to do it. Now, all of this data gets now, as at the end of that funnel, like I said, it all gets sucked into a modern review platform, which is what you're looking at right now. This model review platform that you're looking at happens to be called Relativity. I'm showing another one in just a moment. But all that data gets in there. So all of the emails, all the text messages, all of the social media apps that are important, right? Social media being structured data as well as all of your Word documents or your Gmail, your Google Drive documents, etc. All of it gets culled down so that the attorneys can finally review it and start coding for responsiveness. So that gives you an idea as to where we've been in like the growth of data volumes and types and why it's necessitated or forced us as a legal industry to start changing. So with that being understood, right, we're kind of building a momentum over here, right? We talked about this evolution of legal technology, talked about the growth in data volumes and types. Now it's really important to talk about the history of AI and its use in the legal profession. And to do that, what I want to start off is by showing you a clip of one of my favorite movies from 1983, a movie called War Games. And here you're looking at a very young Matthew Broderick. And if you don't know the context of this, Matthew Broderick is a teenager who knows a lot about computers, a bit of a hacker, and he happens to get into this computer program in which the computer actually talks to him and he talks back to it. And he's marveled by this. And back then in 1983, as a young child watching this movie, I thought, wow, well, this is really crazy science fiction. I can't imagine a computer being able to talk to you and have a human interaction. And of course, now that's not so sci-fi. Take a listen. It thinks I'm Falcon. Hello. I didn't ask you that. It'll ask you whatever it's programmed to ask you. Ah. Yeah. I'll ask it how it feels. I'm fine. How are you? Excellent. It's been a long time. Can you explain the removal of your user account on June 23rd, 1973? They must have totally died. So here he is interacting with the computer. Yes, they do. And the computer is just having a conversation. This box just interprets signals from the computer and turns them into sound. Shall we play a game? Amazing, right? So again, so back then we thought, well, this is really crazy. Like, wow, we can't imagine a computer talking to us. And now, of course, one of the things we're going to obviously talk a lot about is how computers actually do talk to us now. But back then, sci-fi, now is actually a reality. So where did this all generate from? Right? So they really generated back in the 1950s. Artificial intelligence is not something new at all. It actually, as I just said, invented in the 1950s, and it came out first with a gentleman by the name of Alan Turing. Now, Alan Turing created what he called the Turing test. And when we talk about machine learning, it's quite literally a machine. So Alan Turing created this machine and he tested its ability to exhibit intelligent behavior that'd be indistinguishable from a human. So the test involved a human evaluator interacting with a machine and then a human through a text-based interface without knowing which is which. So the evaluator couldn't consistently distinguish the machine from the human, The machine is considered to have passed the test. So he called this thing a universal machine, or the Turing machine, after himself. That was very nice of him to do. But the idea laid the foundation of the development of programmable computers and quite literally machine learning. Now, you take a look at the next gentleman over here. This is John McCarthy. I called him the father of AI. Why? He literally coined the phrase artificial intelligence. We owe it to this gentleman over here. He coined the phrase himself. Now, one of the other things he did besides coining this phrase was he created a programmable language known as Lisp, or list processing. Now, it became one of the primary languages used in artificial intelligence and artificial intelligence research. It was designed to facilitate symbolic processing and manipulation of data structures, making it well suited for AI application. The third thing that McCarthy did that's very notable and made a huge impact in the world of AI back then was created this thing in 1956 called the Dartmouth Conference. This is summer camp for artificial intelligence people, and this was really a groundbreaking time. This little summer camp here, the researchers gathered together and they discussed the potential of creating machines that would simulate human intelligence, right? Creating machines simulate human intelligence. This was a very historic and significant and massive milestone in AI research. And again, it was not invented in the 1990s or 2000s. AI was invented in the 1950s. Now, fast forward from this, we go to this gentleman over here named Frank Rosenblatt. He created a machine called the Mark I. Now, Mark I was also called the perceptron. And the idea here is that if we put a shape, let's call it a triangle, in front of the Mark I, the eye, if you will, of the machine would look at the shape, identify the shape, understand it's a triangle, and then through a series of lines and symbols, it would actually recreate the triangle. Show it a square, it would create a square. Show it a letter, it would recreate the letter. That again was the idea of machine learning. Fast forward again, 1959, Arthur Samuel. This was groundbreaking as well because he taught the computer how to play checkers, or I should say he taught the machine how to play checkers. So this seminal research on machine learning was so important because the program improved its performance through self-play and learning. It actually learned by itself, right? So this unsupervised way of the machine to learn checkers, I also think it was somewhat of the impetus for when they created the movie War Games is actually interesting because they talk about playing tic-tac-toe, talked about playing a game of chess, and it all comes back to and stems from Arthur Samuel's seminal research on self-play with the machine. Now, you fast forward into the next decade, right? So now we're in the 60s, we're in the 1970s. The problem with the 60s and 70s is that there were a lot of theories, but the technology just wasn't there with artificial intelligence. And there wasn't a lot of funding because the technology wasn't there. But in the 1980s, a few very, very good things came out of it. First and foremost, this is Elaine Rich. Now, Elaine Rich, if anybody wanted to study anything about artificial intelligence, she went to her groundbreaking textbook, aptly called Artificial Intelligence. It had covered a broad range of topics such as problem solving, machine learning, natural language processing, which helps students gain a foundational understanding of AI concepts. Again, this was the book of books. This was the Bible of artificial intelligence. We owe a great debt of gratitude to Elaine Rich. Now, also in the 1980s, is this person, Susan Dumais. I consider her being the godmother of modern artificial intelligence. It's so important that we cover this. So Susan Dumais created a programming language called Latent Semantic Indexing, or LSI. Now, she talked about LSI in a paper, aptly named, using latent semantic analysis to improve access to textual information. She published that paper in 1988. The reason why it's so groundbreaking and influential is because in the world of legal technology, LSI is still a programming language that's still leveraged today. Now, LSI aimed to address the limitations of traditional keyword-based approaches to information retrieval. I harken back to the 60s and 70s with Gerald Salton, who created keyword searching. And she wanted to consider the semantic or the language, right? The semantic content of documents, right? Understanding semantically what did somebody mean, right? By saying a specific word. This is a significant advancement in information retrieval. Now, information retrieval is a form of artificial intelligence. It quite literally means that, well, it's pretty obvious, we're retrieving information, but it's using algorithmic-based research and math to be able to retrieve information. And if you can apply natural language processing, meaning the computer understands what we're saying as humans. We saw that little clip in War Games. And semantic analysis, right? Meaning, again, understanding the grammar, the language behind the language. All of this ended up being utilized subsequently in the 1990s. We started looking at things like natural language processing, natural language interface, meaning that we have an interface by which we can start typing in words. Information retrieval means we're finding that information. Query understanding. You should all know that because when you do Google search, it starts to auto-populate words. That's query understanding. The computer or Google is trying to it thinks it understands what you're going to type next. And then document indexing, meaning we're literally indexing everything. So if you put all those five together in the 1990s, all of a sudden we had a place to put all that. Well, where do we put it? Well, in the 1990s, I was in college. And in the early 1990s, there was only one web browser. It was called Netscape. And as you can see on the screen here, we had this big, bulky they were monitors that are called CRT monitors. And we had these monitors, and there was no Google back then. There was one search engine at that time in 1994, and it was called Lycos, lycos.com. And as you can see over here, you could type in some keywords and run a search. So when you type in keywords and run a search, what is it doing? Right? Well, number one, there's document indexing. And number two, there's keyword searching, right? There's some query understanding there as well. And it's finding information and it's indexed the web. So it's information retrieval as well. So all of a sudden what you start seeing is everything that I start building upon before, talking about Turing and Arthur Samuel, right, and Rosenblatt, et cetera, all the way to talking about Susan Dumais. All of this started building up. So it is so important to talk about this artificial intelligence roadmap, the historical underpinnings of it, because next we had Excite.com, and Excite.com was somewhat exciting. This is the first time we could actually make the web more ideal for us because we could identify what we want to see on our homepage or our landing page. And if you're lucky enough, you actually had an Excite.com email address. That was a thing back then. Now, in 1995, 1996, there was a company called Ask Jeeves, way ahead of its time. The butler often got made fun of, which was quite a shame. But this is the first one where in the Ask button, it deployed advancements such as the natural language interface and the query understanding. It started anticipating what you were going to think, right? What it is that you wanted to ask it. Now, this was very, very much ahead of its time. Like I said, when Google came out in 1996, it didn't even have half the tech that Ask Jeeves had, right? So it was important to know, like, hey, this is actually what had happened, and this is where we were. But then you fast forward into the 2000s, right? In the 2000s, we have big data, we have neural networks, we have advancements in powerful computing power that wasn't previously available. So all of those algorithms from the 60s and 70s, they couldn't do anything with. They started all, coming back here in the 2000s. Neural networks inspired by the structure of the human brain gained popularity, enabled significant progress in areas like image and speech recognition. There was a deep learning and AI boom. So there's a subset of machine learning that really revolutionized artificial intelligence in the 2000s. So deep neural networks have achieved remarkable results in various different domains. So things like computer vision, autonomous vehicles. I was just out in San Francisco a couple of weeks ago. One of the interesting things we talk about autonomous vehicles. The Waymo is an autonomous taxi, like an Uber, except no one's in there, and it's the big tourist attraction. It's a self-driving car. that uses big data neural networks. It uses all of the artificial intelligence we just talked about. But of course, there is, and we can't have a conversation without talking about ChatGPT. I'll pause here for a moment because, ChatGPT has created, and generative AI has created really an inflection point as to where we are in the legal industry today of legal technology. It's significant as to where we are today. And I wanted to go ahead and ask ChatGPT a little bit about itself. And so this is what I did. I said, explain ChatGPT to me like I'm in the first grade. And so sure enough, it said, sure. It's like a really smart computer program that can talk to you and answer your questions. Again, I harken back to that, my favorite movie of the 1980s, War Games. It knows a lot of things because it has read a lot of books and articles on the internet. There's document indexing, right? You can ask it anything you want, and it will try to give you a very good answer. Now, it goes on to say, imagine you have a friend who knows a lot about different topics. You can get asked questions like, what is the tallest mountain? Or how do birds fly? And ChatGPT will give you answers. And my favorite part, it's like having a friend, but it's a computer program instead of a real person. I thought that was a very cute way of being able to put it. But what's also very fascinating is this part. ChatGPT may sometimes not know the answer to a question and might give you a wrong answer. It's because it doesn't have real experience like a human. So it's a good idea to double check. Now I'm going to hone in on that part really hard. I'm going to double down on that on the last part of our presentation because it's so important that ChatGPT is not perfect, right? It does give sometimes false answers. Those false answers in generative AI is called a hallucination. It's important to know that because as lawyers, when you go out and you start practicing, as you covered in a previous module, you have an ethical obligation to ensure that you know this information. You double check the generative AI output and that you don't potentially pierce the attorney-client privilege doctrine by putting client information into a commercial model like that. And it's not just me that's evangelizing this, it's also the judges. And it's not the judges are evangelizing that lawyers get current with technology, not just artificial intelligence. For instance, a very famous example is Judge Johnson. He is a US District Court judge in the very famous case of DR distribution versus 21st century smoking. He says it's no longer amateur hour and it's way too late in the day for lawyers to catch a break on e-discovery compliance because it's technically complex or resource demanding. And he went on, if you read that case, it talks about how there the defendant did not take reasonable steps to preserve electronically stored information, didn't conduct a reasonable investigation of that ESI, didn't timely disclose, and ended up spoliating thousands of emails and also chat messages. Also disabled the auto delete function on the email accounts. And as a result of that, there were so many emails that should have been produced that weren't produced in that. And again, you never want to be the lawyer on the other side who is getting chastised by a judge and being codified forever in case law that everybody always reads about or somebody's presenting about like I'm doing here today. Now, another very famous case is by Judge Laster in the James versus National Finance matter. Here again, talking about the deliberate ignorance of technology is inexcusable. And if a lawyer cannot master technology suitable for the lawyer's practice, the lawyer should either hire tech-savvy lawyers tasked with the responsibility to keep current or hire an outside technology consultant like me who understands the practice of law and associated ethical concerns. Clearly here, Judge Laster quoting the Model Rules of Professional Responsibility, Rule 1, about competency, we'll talk about in just a second. So again, it's important to know that today there are so many more features and functionalities that mechanistically for you to be able to search for data, because as we talked about, and the reason why I built up this presentation, this module, the way that I did, is because there are data volumes and the different data types are so expansive. They have exploded in a very, very short period of time. And the data has gotten so much bigger in a very, very short period of time is that you can no longer get by on just keyword searches and Boolean searches alone. So everything we talked about so far leads up to where we are right now. And so modern e-discovery, electronic discovery software programs have lots of technology built into it. To Judge Laster's point, it's incumbent upon us as attorneys to really understand that or find somebody who does understand it who can help you with that. And it's not just this one program that's called Relativity. There's another program called Everlaw. And like I said, there's a lot of various different technologies that are built into it that are artificial intelligence, that are not generative artificial intelligence. So I want to take a moment to talk about some of those. So in this particular slide, the little animation you saw, something called email threading. So email threading is a form of artificial intelligence. It's an advanced analytical function. And this allows you to basically take all of the related email communications, all the related email conversations, to be grouped together as threads like you would see in Gmail or other popular email programs. This feature actually helps provide a much more comprehensive view of all the email communications and facilitates the review of email chains in a much more organized and much more efficient manner. So in layman's terms, just imagine having to read every single email that goes forward, forward, and you're reading the same thing over and over and over again. Again, email threading groups it into what we call the most inclusive email. So the attorney can read the most inclusive email, and if they really wanted to, she could read all of the duplicates or she could read all of the rest of the emails in the thread. But email threading is also visual in nature, so the attorney can go ahead and she can review that visualization of email threading to see the straight line of all the responses, where it breaks down, where somebody forwarded communication, and all the responses, forwards, etc., etc. So email threading is a form of a very simple and easy digestible understanding of AI and legal technology. I love a lot of the visual stuff here. So this over here is a visual communication analysis, and this allows you to see a grouping of what we call name normalization. So Daniel Gold can have 10 different email addresses, for instance. And so name normalization normalizes all the 10 different Daniel Gold email addresses into one Daniel Gold. And what it literally does is it takes a look at all the various different emails, and the bigger the bubble means more communications. So it tells you where each one of the entities or the named persons or custodians, whatever you want to call them, where they've been communicating or who they've been communicating with. So better than looking at like a database, email after email or document after document, this visually allows you to see who is talking to who, and you can manipulate this, take a look at it by different dates, etc. And again, this is all being done through the value of having various different algorithms. Now, one of the algorithms I actually love the most, and one of the ones I always encourage lawyers to do and always use, I think it's like table stakes analytics, table stakes AI, is something called concept clustering. So what you see in this very visual and colorful page here is document indexing. Again, that's an AI algorithm, right? And information retrieval. So it basically indexes all the documents. So let's say you've got 1 million documents, it indexes all of them, and it takes concepts, in other words, one word, and creates a concept from that word and groups together all the various different words that are conceptually related to that one main word, right? So this is so much more powerful than keyword searching. So I want to take a moment of brevity again, a little comic relief here, and I want to give you an idea as to how concept searching works. Again, it's one of my favorite, easy, low-hanging ways of being able to do something way more powerful than just keyword searching or Boolean searching alone. And I'm going to give you a very good example here. So as you all know, this is the infamous Taylor Swift. Now, let's say I'm performing an investigation of Taylor Swift. I don't know much about her. Now, if I were to just do a keyword search, Taylor Swift in quotation marks, I would just come up with what? Where Taylor Swift is, I'd just only come up with results with Taylor Swift. The only documents I would get back, the only emails or text messages I would get back, in quotes, Taylor Swift. But that's highly limiting in nature. So conceptual searching, again, finds concepts based upon its AI algorithm of document indexing and grouping together certain keywords that are all conceptually related. The algorithm figures it out, right? So what could be conceptually related? So let's say I'm performing this. Now I'm doing concept searching. Well, I would never ever have known just by doing a keyword search that her cat named Olivia Benson, right, was conceptually related to Taylor Swift. Now, I wouldn't have known as well just by doing keyword searching that 1989 was something as well that was conceptually related to Taylor Swift. So I would have known that, and I would have lost so many valuable documents, right? So understanding that. So Olivia Benson, the cat, 1989, conceptually related, and of course, well, I don't need to say anything else. So you can see how concepts are so much better than keyword searching alone. Okay, so there's keyword searching. Now, another technology which had made a lot of waves that I want to talk a lot about here is predictive coding, also known as technology assisted review, also known as several different things, continuous active learning, etc. This is a way of being able to basically be able to code the corpus of documents to understand what is potentially responsive, non-responsive, simply by coding just a few documents. So just by coding a few documents, all of a sudden, it's able to now recode all of the other documents within the entire corpus as responsive or non-responsive. And finally, you get to a point of dwindling returns where it doesn't make sense, as you can see in the visual, of really being able to, why go through the process of reviewing any other documents when the computer program is basically telling you, the algorithm is telling you, it's not going to be responsive. So this made a lot of headway. So Maura Grossman, I consider her the godmother of modern e-discovery, right? Because Maura Grossman, she came up with this, she really popularized the concept of computer-assisted review or technology-assisted review in this seminal paper that she did in the Richmond Journal of Law and Technology. And this paper was so valuable and so important, and she talked about it being so much better than this keyword searching. Now, Maura Grossman created several different studies on the idea of technology-assisted review, went into the heart of the algorithms and the AI, the science behind it. Now, do you have to read all of these? No, right? Are they important? 100%, right? But again, it's the understanding of the technology is there and how it works. In 2012, now retired Judge Peck wrote this seminal opinion called De Silva Moore, where in De Silva Moore, he actually said that technology assisted review was okay for lawyers to use. This was huge because before, it wasn't okay, right? No judge had ever said it was okay. And just a couple of months later, another important decision out of Virginia, Global Aerospace versus Landau Aviation. My friend Tom Grix was the attorney that argued in favor of using technology-assisted review, and that court said it was granted. So 2 courts in a row was just the start of many, many cases that said technology-assisted review is okay. And there he is, Tom, on the cover of the Wall Street Journal back then, how a computer did the work of many lawyers. Now, people like to say, well, I don't really understand how predictive coding or computer-assisted review works, et cetera, or active learning. How does that work? And the way it works is very much like the way Spotify works. So continuing along the theme of Taylor Swift, let's say that I'm listening to Taylor Swift and I am a Swiftie, okay? And I really like the song I'm listening to in Taylor Swift. I can give it a thumbs up in Spotify. It's the same as giving a document, right, a responsive tag in eDiscovery and predictive coding. By giving it a thumbs up in Spotify, the same as eDiscovery, the computer program is coding all the other documents. It's like, oh, okay, this one's responsive, so too must the others. Similarly, in Spotify, I don't need to be a music major to understand or understand the millions and millions and millions of songs that are out there, right? Or listen to all the songs that are out there. I just need to give this a thumbs up. And if I give it a thumbs up, maybe I'll get back Gracie Abrams, right? And if I give Gracie Abrams a thumbs up, hopefully I'll get back another song that's like it. But if I don't, there's Nickelback, and I'm not a big fan of Nickelback. I'll give it a thumbs down, right? And now I won't get other artists or songs like Nickelback. So it's important to note that computer-assisted review, active learning, whatever you want to call it, continuous active learning, it works the exact same way as music theory does with Spotify. Thumbs up, thumbs down. And so with all this talk of technology, one of the things that you may have read in advance of today's module is Richard Susskind, The Grid, Tomorrow's Lawyer. It really captures the core message. Technology isn't just about efficiency, it's about transformation. And law firms that once saw technology as just a support tool now realize it's fundamentally altering how they work and how they deliver client value. And that's very important. So, from automated tasks to predictive analytics, the firms that embrace this shift will be those that are thriving in a rapid evolving industry. Though, notwithstanding what the New York Times recently said, no AI is not coming for lawyers again. But what's interesting to note is Dean Perlman of Suffolk University Law School said something fascinating, which is AI will not eliminate the need for lawyers, but it does portend the end of lawyering as we know it. Very, very important. Now, if we take a look at how ChatGPT says it could help lawyers, it says it could help lawyers in various different ways, from legal research to drafting documents to legal analysis to even continuing legal education courses. But I hope not, because I really enjoy doing this, and I hope ChatGPT doesn't take that away from me. Right. So what's important to note, though, is that legal professionals should always review and verify information provided by ChatGPT to ensure accuracy and compliance with applicable laws and regulations. Also, one of the things you may have read in advance of today's module, right, is this, right, from this article was really important quote from ABA Journal 2024. ChatGPT presents or represents rather an advance over previous efforts by letting users submit queries in natural language and get responses that mimic human behavior. It's like having a super computer in the form of an aide or assistant. But like an aide or assistant, they may or may not get things right. And so it's important to note that as well. So this is an example that I did, a real example from three generative AI large language models. This is the prompt that I gave ChatGPT. I gave it to two other Gen AI tools. And it said, I am an attorney. Draft me a legal memorandum on the admissibility and authenticity of a screenshot of a text message in federal court. And here's the thing. All three gave different responses. Some of them are very accurate, some of them are not so accurate, some of them are a little bit misleading. And what's important to note is that, again, we have this ethical responsibility to be able to make sure that we are checking the work. And if ChatGPT gets it wrong, as abovethelaw.com, the really great article that came out last year, it said, once again, it's a mistake to pin the screw ups on ChatGPT. Lawyers have an obligation to check their work. There's nothing wrong with asking the system to answer a question, but then whatever the bot spits out, the attorney needs to check it against the reality, preferably before filing that brief. And again, in the ethical module, you covered some of this. But again, it's important to note, though, as a reminder, a refresher, I can never say it enough. I'm very passionate about the ethics component of this, is that Rule 1.1, comment 8, an attorney must understand the benefits and risks associated with relevant technology. It's become so pervasive that many courts across the country now have civil practice orders or standing orders on the use of generative artificial intelligence, talk a lot about being able to be transparent about the fact that it's being utilized, and both parties need to agree to the fact that generative AI is being utilized and advise the court that it's being utilized as well. We're also seeing generative AI show up all over with various different areas of practicing law. It's not just e-discovery. In the world of e-billing, we're seeing Thomson Reuters, legal with their product Legal Tracker, on it, Clio. In the world of legal drafting and research, CoCounsel, Harvey, Spellbook, and Jasper. And other core research, case law statute, we're seeing it with Lexis, we're seeing it with Westlaw. Contract management is a really big one right now. Law Geeks, Kira, Luminance, Contract Pod AI, and obviously with e-discovery, we talked about relativity, and we talked about Everlaw. So we're seeing this come out more and more with the tools like Relativity's artificial intelligence review, be able to automatically be able to start coding documents way faster than the predictive coding, the assisted review, because now we're putting prompts in. We're putting prompts in, the computer is then going in and then letting you know what it thinks is responsive. Everlaw AI Assistant is really doing very much the same with multiple areas across its platform to be able to showcase how artificial or generative artificial intelligence is being utilized. The point here is this. Generative AI has hit the legal profession in ways that no one ever expected. Generative AI is talked about at the breakfast table, the dinner table, our partners, our spouses. We're all talking about it. Our kids are talking about it. Grown-ups are talking about it, etc. And it is here now in the legal profession. And it is something that is pervasive. And again, I noted it before, and not to sound too melodramatic, but we are at this inflection point. And it is actually an amazing time to be a law student and to graduate college with this kind of technology available. And as the International Bar Association president had said, that this is really a transformative impact, and it cannot be ignored, right? It cannot be ignored, and you can't do what ostriches do, which bury your head in the sand. We have to confront this, and as the future of the legal profession, it's an exciting time, like I said, for all of you. So if you want to know more about where we are with legal technology, where we are with artificial intelligence, and in particular, generative artificial intelligence, there's so many really great places for all of you to go to. So there's podcasts. So you all know about the National E-Discovery Leadership Institute, or NELLI. I started the podcast for them. BDO, I mentioned it before. I'm a podcaster at BDO, Legal Tech Talk. The Electronic Discovery Reference Model, EDRM. My friends Mary and Kaylee run that podcast. My friend Ryan he does eDiscovery After Hours podcast. My friend Kelly Twigger does Case of the Week. My friend Laura does that Tech Pod. And there's also the Geek in Review. You've got great webinars and courses offered by Relativity, Everlaw, the International Legal Technology Association called ILTACON, the Association of Certified E-Discovery Specialists, or ACEDS. Coursera does courses on legal technology and artificial intelligence, and a vast variety of articles, blogs, and forums for like law.com. Also, LinkedIn and Reddit have great groups and forums, subreddits to take a look at. Obviously, the Artificial Lawyer, Legal IT Insider, the Sedona Conference. And there's plenty of conferences for all of you to go to, like NELLI, of course, every year. There's also Georgetown, there's EDI, or Electronic Discovery Institute, the Sedona Conference, etc. So there's so many really great opportunities for you. And I'm hopeful throughout this time that we've spent together today, you've understood the evolution of legal technology, the growth in data volumes and data types, the fascinating history of AI and its use in legal legal profession, and also the ethical considerations of Gen AI and legal, where we are today, and how to keep current with all of the changes. And with that, I'd like to thank all of you very much for spending this last hour with me. And I encourage all of you, if you ever have any questions whatsoever, I love to be able to help out as much as I can. It's always a fascinating topic. Feel free to reach out to me. There's my phone number, as well as my email address. And if you want to take a look at what we do here at BDO, maybe that may be a profession you want to take a look at. Come work here at BDO. That'd be great as well. Happy to talk to you about that too. That's all for now. Thank you so much. Take care.